the claimant the sum of 106,970 naira 25 kobo as monthly salary and applicable allowances from October the 21st, 2019, when the claimant resumed work at the defendant's university from her medical leave. An order of the Honorable Court that the claimant shall pay post-judgment interest on the above sums at the rate of 22% per annum until the liquidation of the entire sums. The claimant's case. Catherine U. Kufuruji was appointed as a lecturer in the Department of Metallurgical and Materials, Faculty of Engineering, University of Lagos in 2007. She was granted study leave with pay to undertake her PhD program in Canada from August 1st, 2010 to July the 31st, 2013, which was formally extended by the university from August the 1st, 2013 to August the 31st, 2015. That she did not resume duty, neither did she apply for extension at the end of the approved study leave. Thereafter, her salary. So 2018, that is about 2 years and 10 months later, the university acknowledged a later resumption of duty on July the 18th, 2018, but requested her to explain the delay in a resumption to duty. On July 26, 2018, she responded with the following reasons: that PhD program in Canada takes upwards of 4 years compared to UK and Europe, which is 3 years. That she had extensive requisite laboratory work and some courses pursuant to satisfying the comprehensive examination requirements post her oral examination. That on completion of the PhD in December 2016, her thesis was sent out for evaluation and the thesis defense was held on the 8th of May 2017. She had to wait for a convocation and formal award of a PhD. Lastly, her late resumption was due to financial constraints occasioned by the stoppage of a salary for most of the period of the extension of the PhD program. She concluded, and I quote, "And I take responsibility for not writing an extension letter for the periods mentioned," end of quotation. On August the 23rd, 2018, about 50 days after resumption, she applied for an 18-month study leave without pay to undertake an MBA program at the University of Ottawa, Canada. That 6 days later, on August 29, 2018, another application was forwarded for a 5-week medical leave while awaiting a response for the 18-month application for study leave. Meanwhile, the university on August 30, 2018, in acknowledging the said assumption of duty letter of 3rd July 2018, welcomed her back to the university and requested her to forward 5 copies of study leave report to the APB. That's the Appointment Promotion Board. That in the month of September 2018, she traveled to Canada on the 3rd for her medicals without any response from her employer. And on the 11th of September, same year, 2018, the university formally refused the earlier application for study leave without pay for MBA due to her long-term study leave and the condition of her bond. However, on September 12, 2018, she received a promotion letter to Lecturer 1, effective from October the 1st, 2018. 2 letters were issued. First letter was to convey non-approval of a medical leave. And in the second letter, the university management directed her to resume at a duty post immediately or her salary would be stopped. That on October the 11th, 2018, the claimant forwarded 2 acknowledgement letters to the university in respect of the refusal of the application for 18-month study leave without pay for MBA program and refusal to grant the medical leave. Further, she stated that on the 19th of November 2018, she received a query for being absent from work without permission. She responded in November 26, 2018, that she was receiving specialist medical care and attention from a doctor in Canada. That she was invited to interact with the investigative committee on allegations of abandonment of duty leveled against her on November 27, 2018, and she asked for it to be rescheduled because she was still in Canada. That fast forward to 2019, another invitation was extended, dated August the 15th, 2019, to interact with the defendant's administrative panel set up to investigate the allegation of abandonment of duty leveled against her. This was done mostly through email. that on October the 21st, 2019, the claimant concluded her medical treatment and resumed at the university. She appeared before the administrative panel about January the 8th, 2020, and appeared before the Senate committee on November the 8th, 2020. The claimant formally wrote to the defendant severally to assign her with teaching courses and to pay her outstanding salaries. She was advised to await the management decision from the panel. That on July the 16th, 2023, with reference number AD/REG/11326, her appointment was terminated, authored by the registrar and secretary to council, issued under the authority of the governing council of the University of Lagos, in bracket the council. The defendant's case. The defendant's case is that the claimant throughout the duration of her appointment with the defendant was on probation. She went on study leave with pay from the 1st of August 2010 to the 31st of July 2013, and it was extended twice with approval from the 1st of August 2013 to the 31st of August 2015. That the claimant didn't resume duties after the second extension period had lapsed. She only resumed on the 3rd of July 2018. The university maintained that no further study leave extension period was ever sought or granted to the claimant to warrant her resumption on the 3rd of July 2018. The university drew her attention to the late resumption and requested for an explanation that by regulation governing the condition of service of senior staff, an employee who fails to resume duty as at when due forfeits his or her salary and may be subject to disciplinary action. Her salary was therefore stopped. That her resumption on the 3rd of July 2018, her salary was not restored because her reasons for her absence/abandonment of duty was still being examined and considered to determine the next course of action. On August the 23rd, 2018, the defendant's case is that barely 7 weeks after resumption, she applied for another 18-month study leave without pay to pursue an MBA program in Canada, and applied later for a 5-week medical leave. Both applications were not granted. The university maintains that she abandoned her duty without approval after her PhD program between the 1st of September 2015 and the 2nd of July 2018, that is 2 years and 8 months, and did same without permission between the 4th of September 2018 and the 20th of October 2019, that is 1 year and 37 days. That following routine administrative procedure on the 30th of August 2018, the university welcomed the claimant back from her studies and asked her to forward copies of a study leave report to the APB. These procedures did not stop the university from examining the issues of misconduct under the regulations governing the condition of service. The defendant's case is also that she was issued with a promotion letter on the 12th of September 2018. And on the 27th of September 2018, she was informed that her medical leave had not been approved and directed her to resume work immediately or otherwise face disciplinary action. That a formal query dated the 19th of November 2018 was issued, and she was given 48 hours to respond. On the 27th of November 2018 and the 15th of August 2019, the claimant was invited for an interaction with a committee set up to investigate the allegation of abandonment of duty leveled against her. That on October the 21st, 2019, she resumed from a medical leave and appeared before the Senate committee. On the 16th of January 2023, her appointment was terminated. During trial, CW1 tendered exhibits C1 to C36, while DW1 tendered exhibit D1 to D3. The exhibits are all mentioned in the body of the judgment. Next is the defendant's final address and issue for determination. I'm going to skip that and go straight to the decision of the court. All arguments are embedded in the body of the judgment. The court's decision. The The court will examine the relief sought by the claimant Sarah team in taking its decision. The first relief is for a declaration that the claimant's action of traveling to Canada to receive urgent specialist medical care and attention for a medical condition from a doctor in Canada who has been treating her over the years rather than undergoing treatment from a different doctor does not amount to abandonment of duty, misconduct, or gross misconduct. The parties are in agreement that the university did not approve the 5-week medical leave of the claimant after her resumption in 2018. During cross-examination, claimant confirmed that her application was not approved and she did not return to a duty post even when directed to resume work immediately in Exhibit C12. The regulations in Chapter 10 provides intricately for sick leave, presentation of a sick certificate, and absence on sick leave. A sick staff is regarded as absent on sick leave if he presents a sick certificate issued by a medical officer in the university clinic, or where the illness was an emergency or took place during weekend. A sick report from an outside doctor will be valid for 2 days if submitted to the medical center for endorsement by the Director of Medical Services. In claimant's witness statement on oath, paragraph 18, she deposed to the fact that she applied for a 5-week medical leave for urgent specialist medical care. There was no prior documentation before her employers to show her health status. Claimant had ample time to visit either the university medical center or give a report from an outside doctor to certify her medical status in compliance with the regulation, even if she was more comfortable with the Canadian-based doctor. After all, she resumed on the 3rd of July 2018 and applied on the 23rd of August for an 18-month study leave without pay. And on the 29th of August, she applied for medical leave before traveling on the 3rd of September for the medical emergency. It is tried that rules and regulations governing conditions of employment are made to be obeyed, and employees cannot pick and choose when to comply with them. The court also observed during trial that there was a lot of connection between the application for MBA program and the application for medical leave. The court observed that the application for medical leave, Exhibit C8, came about 10 days after the application for study leave without pay, Exhibit C7. The court noted with interest the coincidences of time, date, and how the events unfolded. The admission letter attached to Exhibit C7 indicates that the MBA was a full-time program scheduled to commence on the 1st of September 2018. During trial, the Learned Defense Counsel raised objection to the admissibility of the attachment of Exhibit C7, which is the admission letter, because it was not front-loaded and no reference was made to it that it was attached. Leonard Silk felt ambushed, but in order to save the time of the court, he considered that copies of the attachment should be supplied to him. The court gave an order that the claimant counsel should make copies of the attachment available to the Leonard Silk after the day's proceeding. In O2 versus Integwile, citation provided, the Court of Appeal held that once a document has been tendered as an exhibit, the court has a right and a duty to refer to any portion of the document in order to arrive at a just decision. The admission letter for the MBA program was dated 11th of July 2018, and the deadline to accept the offer and pay the non-refundable deposit of $1,000 was August 1st, 2018. In the application letter for study leave without pay, Exhibit C7, dated 23rd of August 2018, the claimant in paragraph 3 stated, and I quote, I was only just notified by the University of Ottawa about my admission, and as such was not in a position to optimally structure my resumption schedule in the circumstances. I had requested for a deferment of the program from the University of Ottawa. However, my request was declined as I was advised that the program could not be deferred, end of quotation. In paragraph 4, she continued, and I quote, I therefore had to proactively make payments for the program in order to guarantee my spot for the session. And this payment, unfortunately, is non-refundable, end of quotation. This information casts doubt on the claimant's sincerity in Exhibit C8, that is, the application for medical leave. It is obvious to the court that she already had the admission secured in Ekiti 23 days earlier before applying for study leave without pay. And after reading the body language of the university management, she feigned ignorance of the offer of MBA admission dated 1st of August 2018 and applied for medical leave on the 29th of August. This singular act casts reservation on the conduct of the claimant before this court. She has ruined any rational basis for accepting the evidence in part or in total based on credibility. See Oguntayo versus Adebutum. Citation provided. During cross-examination, she was asked why she did not do the MBA program in Nigeria. She responded, and I quote, "The intent was to do it in Nigeria." End of quotation. From the evidence before this court, it is clear that the claimant had no plans to do this MBA program in Nigeria. She had paid a non-refundable fee of $1,000 to secure her admission. It is on record that the claimant had mentioned lack of funds as one of the reasons for a late resumption of duty in 2017 after the defense of her thesis. It is startling how claimant was able to raise $10,000 to pay the entire school fees when she had testified that she was not working during her PhD and financial constraint was one of the reasons she resumed late after the PhD program. Claimant's action of traveling to Canada to receive medical care and attention from a doctor, rather than undergoing treatment from a different doctor, does amount to abandonment of duty because no approval was ever granted before embarking on the said leave. In effect, she was absent from duty without approval, which is a misconduct. Relief if fails, I so hold. The second relief is a declaration that the procedure of the defendant's administrative panel and Senate committee in failing to afford the claimant the opportunity to hear the testimony of the various witnesses called by them in their respective proceedings, and the failure to also afford the claimant the opportunity to confront and cross-examine these witnesses amount to breaches of the right of the claimant to a fair hearing. Heavy weather was made about lack of fair hearing in the procedure of the administrative panel and Senate committee in failing to afford the claimant opportunity to hear the testimony and cross-examine the witnesses. From Exhibit C36, it is established that the panel contacted the claimant via email dated August 15, 2019, and claimant responded the very next day that she was still undergoing treatment in Canada and was scheduled for a check-up in September. When the panel asked for evidence of the scheduled medical appointment, it was indeed provided, and the panel requested that the medical report should be put on the hospital's letterhead. Her doctor informed the panel that the Canadian hospital system was different from the Nigerian system, so that request could not be granted. Going forward, the panel sat 6 times, and from the report, there was cross-exchange of questions and answers through email. In Exhibit C36, the report of the panel states that this panel resolved to further interact with the claimant by eliciting her response to questions sent to her by the panel. On page 10 of the terms of reference 2, it is stated that the panel interacted extensively with the claimant through the secretary by email. Questions were put to her in writing and she responded freely, and the answers were thoroughly considered by the panel. A look at the minutes of the meeting held on Tuesday, the 19th of September, 2019, paragraph 4, line 36. In that document, reference was made to an answer to the investigating panel dated 4th of January, 2019. In addition, after thorough review of the letter from her doctor, a total of 31 questions were forwarded through her email address for a response. Finally, on the 8th of July, she appeared and interacted with the panel. During trial, the claimant raised the issue of not being allowed to cross-examine the witnesses who gave evidence, and Leonard asked her, "Would that be possible when you were not present yourself?" End of quotation. And she responded, and I quote, "I communicated with the panel and was physically present on January the 8th, 2020, end of quotation. Facts admitted are no longer issues before the parties. See Judicial versus Okulo, citation provided. With regards to paragraph 39 of claimant's witness statement of oath, where claimant alleged she was not afforded a fair hearing, CW1 was asked if she was afforded the opportunity to explain why she was absent from duty for the past 3 years and some months. Her response was yes. The question to the mind of the court is, at what point did she have this opportunity? Can excuse that she was not afforded a fair hearing stand? This court is convinced that the defendant's panel utilized electronic medium optimally via email to interact with the claimant in spite of her inability to be present physically at the sessions. In addition, the Leonard Claimant Counsel submitted in its argument and urged the court to hold that the administrative panel and Senate committee of the defendant failed to act in good faith because the chairman Senate committee, Professor F.E.A. Leslie, who was the former provost of the College of Medicine and had been a witness in reviewing the medical report, also testified at the panel and was the chairman of the Senate committee investigating the same matter. DW1, under cross-examination, also testified that he was the secretary of the defendant Senate committee, thus affirming that he was directly thereon. In Walker versus Chukwuemeka Odumegwu, Ojukwu University Teaching Hospital, Awka, and another, suit number NICN AWK/51/2022, before Honorable Justice J.I. Tagema, PhD, his lordship stated that an administrative panel set up is not a court or a tribunal established by law. As such, strict compliance of Section 36 of the 1999 Constitution does not arise. That is the common law form in terms of the rules of natural justice as expressed in the Latin maxim, Audre altrum partem, anemo judax in causa sua. Fair hearing in the world of work has been successfully watered down to just opportunity to be heard. In the light of the above, this court is convinced that the principle of fair hearing was afforded the claimant. In the circumstance, it is the finding of this court that there was no breach of the right of the claimant to a fair hearing. C. Cecilia Arinze versus University of Lagos, unrepeated suit number NICN/LA/305/2017, a case decided by Honorable Justice B.B. Kane, PhD, the President, Honorable National Industrial Court of Nigeria. Relief B fails accordingly, and I so hold. The third relief is a declaration that the procedure of the governing council of the defendant in approving the recommendation of the Senate committee of the defendant to terminate the appointment of the claimant with the defendant without first hearing the claimant was improper and unlawful. Did the governing council fail to first hear the claimant before approving the recommendation of the Senate committee? The procedure for the governing council to take when an academic staff of the university should be removed from employment on grounds of misconduct is provided for in University of Lagos Act, Section 18, Sub 1, Sub B, Sub 3. And I quote, and if the council, after considering the report of the investigating committee, is satisfied that the person in question should be removed as aforesaid, the council may so remove him by an instrument in writing signed on the directions of the council, end of quotation. The University of Lagos Act did not provide for the governing council to first hear from the claimant before approving its recommendation. The procedure for all forms of hearing is provided in Section 18, Sub B, Sub 1 and 2. It is settled law that the interpretation of a document or statute where the words used are clear and unambiguous, it should be given their ordinary meaning. See First Bank of Nigeria Limited versus Ogwemo, where Mohammed Lawal Shuaibu, Justice of the Court of Appeal, at page 24, stated, it is also pertinent to note that in constraining the provisions of statute and by necessary implication, a document where words are clear and unambiguous, it is the word used that prevail and not what the court says the provision means, unless we're given a literal interpretation might lead to absurdity, end of quotation. Similarly, the Court of Appeal in Etokana versus Union Bank, per Abubakar Muazu Lamido, JCA, at page 30, held and stated, now, and I quote, now it is a settled principle of interpretation of documents that where the language used by parties in couching terms or provisions of the document are clear and unambiguous, the court must give the operative words in the document their simple, ordinary grammatical meaning, end of quotation. In view of this rule of interpretation, this court finds that the governing council complied with the provisions of the University of Labour Act in removing the claimant from employment. A look at the University of Calabar Act, Section 16, Sub 1, is distinguishable from the University of Labour Act, Section 18, in that under the University of Calabar Governing Council gives notice of reasons to the person in question. The council shall again afford him the opportunity of making representation in person on the matter to the council. While in the University of Lagos Act, the governing council is not to conduct another hearing, but merely to consider the report of the Senate committee and take its decision. Let me also address Learned Claimant Counsel's argument that the defendant's governing council failed to issue the claimant with a requisite statutory notice which commenced the disciplinary proceedings against them. The implication of this breach/failure to abide by the stated procedure is a fundamental vice, vitiating all deliberations, decisions, and recommendations. Therefore, for employment with statutory flavor, the employee could be reinstated. The claimant counsel argued that the questions, findings, and recommendations of both the administrative panel and the Senate committee dwelt on the claimant's failure to resume from an earlier PhD study leave by July the 31st, 2015, whereas the query addressed the claimant's absence from medical care without approval. Dated September the 4th, 2018. For ease of reference, the first three paragraphs of the query is reproduced in the body of the document of the judgment, and it deals with the allegation. And for the letter of termination of appointment, the second to the fifth paragraph is also hereby reproduced. And I read, query exhibit C16. You would recall that your application for study leave without pay was not approved by the university management via a letter dated 11th of September 2018. You also applied for a medical leave but was not approved by a letter dated 27th September 2018. The management paragraph 2 goes for them. The management, however, discovered that you have been away from duty since the 4th of September 2018 without the university's approval, which is against the extant rule and amounts to abandonment of duty. This allegation is serious and tantamount to gross misconduct. Paragraph 3. Kindly explain why disciplinary action should not be taken against you for this act of gross misconduct. The termination of appointment letter. Paragraph 2 reads, Council noted that you were granted study leave from August 1st, 2010 to July 31st, 2013, which was extended to July the 31st, 2015, and that you did not resume duty till July the 3rd, 2018. Paragraph 3 reads, Council also noted that you proceeded on an unapproved medical leave on September the 4th, 2018, and resumed duty on October the 21st, 2019. The University Authority thereafter set up an investigative committee and administrative panel to determine your culpability for the alleged abandonment of duty, which is a misconduct under the regulations governing the conditions of service of the senior staff of the University of Lagos. Paragraph 4 reads, Council approved the recommendation of the Senate committee that your appointment should be terminated with effect from Monday, January 16, 2023, in accordance with Section 18 of the University of Lagos Act. Paragraph 5 reads, Council has approved that you refund the salaries and allowances paid to you beyond July 31st, 2015, which you should have resumed duty from your study leave. The report of the administrative panel in Exhibit C36 had its terms of reference 3.0, number 1, and I quote, to peruse the attached report of the committee that investigated the allegation of abandonment of duty against Dr. C.U. Kufuruji. It is indeed noted that the query did not raise the issue of late resumption of duty after completion of PhD program. This issue was already being considered by the university management in Exhibit C5. That was why her salary was not restored and she had not been assigned teaching courses. See Exhibit C23, Exhibit C24, Exhibit C25, and Exhibit C26. The response between the university in Exhibit 337, paragraph 3, and the claimant in Exhibit C38 and Exhibit C29 is an indication that the claimant understood there was a decision being awaited one way or another on her late resumption to duty after her PhD program. This court is convinced that after studying the report, that the second major allegations of misconduct were addressed, that is, late resumption after PhD program in July 2018 and proceeding on unapproved medical leave in September 2018. Let me at this point address the Learned Claimant Counsel's argument that the defendants were non-compliant with Section 18 of the University of Labour Act. In other words, the council failed to issue statutory notice to query, which commenced the disciplinary proceeding. Counsel was expressly mentioned to be the issuer of the notice/query, but the query was not of employment, Exhibit C32. While Exhibit C16, although signed by the registrar and secretary to counsel, vitiating all the deliberations, the decisions, in Idacha, the Supreme Court held delegation to mean that powers are committed to another person or body, which is, as a rule, always subject to resumption by the power delegating. In Foot Yola versus ASU, citation provided, also held that the appropriate authority can delegate the powers conferred on him to whomsoever he shall authorize to exercise such powers. Since the powers are exercisable personally or through a delegate, the method of delegation of the power is not exhaustive. To exercise the powers, but there must be delegation. In the query, Exhibit C16, and the termination letter, Exhibit C32, where both were issued under the hands of the registrar and secretary to the council. The letters of appointment as assistant lecturer, Exhibit C2, regularization, Exhibit C3, and promotion letter, Exhibit C4, and Exhibit C11, they were all signed under the hands and on behalf of the registrar and the council and the secretary to the council. The action of the registrar to issue the query, which is the bone of contention, is not a breach of the regulation. The action of the registrar was a delegated action on behalf of the council. Therefore, Exhibit C, Relief C, and Relief F fails, and Relief G, in view of the above reasoning, for an order of reinstatement also fails. After the claimant resumed from her PhD study leave on the 3rd of July 2018, the defendant, in his letter of 18 July 2018, which is Exhibit C5, paragraph 5, observed that by the 2 extensions, she was expected to resume on the 1st of September 2015. And in paragraph 6, she was asked to explain why she was resuming late. Claimant gave explanation in Exhibit C6. She acknowledged that she completed a program in December 2016, but defended the thesis on the 8th of May 2017. In paragraph 4, she stated that she was also without pay during most of the period of extension. What the court can deduce from the above exhibit is that the claimant did not apply for extension after 2015, neither did she return to a duty post. The university thereafter invoked the provisions of the regulation and stopped her salary. Claimant has always maintained that the welcome back letter of 30th August 2018, Exhibit C9, and the promotion letter of 12 months from raising the issue of a late resumption after her PhD program. During cross-examination, claimant told the court that she got 2 approvals for extension to 2015, but she did not get extension beyond 2015, and she did not apply for an extension. Although she defended the thesis in 2017, she still did not resume till the 3rd of July 2018. She further testified in court that she did not have any letter from the university in Canada extending her stay after the thesis defense. At trial, it was established that up until the time she applied for study leave without pay and medical leave, she was yet to even submit her mandatory 5 copies of a study leave report in compliance with Chapter 10, Sub 5C, Sub 3. This is an undertaking provided for under the conditions for study leave. She had to be directed to forward same on the 30th of August 2018 in her welcome back letter, Exhibit C9. Was still under cross-examination, she testified that she did not receive any letter from the defendant waiving the right to question her on her absence. In view of the above facts, can the court be persuaded that the defendant is a stop from addressing the issue of late resumption of duty? It was agreed by both parties that even after the July 3rd resumption, the salary of the claimant was not restored in spite of all the letters she wrote requesting for restoration and assignment of classes. She was advised to await the decision of management on her late resumption after her PhD program. The claimants believed that the university was a stop from raising the issue of a late resumption to duty. She was aware of a late resumption. She was aware that her late resumption was an outstanding issue and yet to be decided one way or another. The relieved witness statement on oath, paragraph 40, had deposed to the fact that she had not been paid the outstanding salaries. Upon resumption from a medical leave, she had written several letters for restoration of her salary. In Exhibit C23, And C26, she wrote to the defendant to restore a salary which was not done until a termination. The defendant did not tender any pay slip, salary payment, voucher, nor any evidence of payment of salary before the court. Can the defendant's counterclaim of 2,829,188.54 kobo, being the salary paid to the defendant from September 2015 to June 2018, during her absence from duty succeed, counterclaimant did not prove to the satisfaction of the court his claim as per Relief E. So the court cannot order a refund of the said salary. Exhibit E succeeds. The claimant is seeking for an order for payment of salary for the month of July 2018 to August 2018. Claimant is not requesting payment for the period August 1st, 2015 to June 30th, 2018. That's the period between the end of the approved PhD study leave and the time she had in fact resumed. And September 4th, 2018 to October 20th, 2019, the period she went to Canada for treatment for a medical condition. The claimant has recognized the fact that she is not entitled to salary for work she did not work, for period she did not work. The period from September 4th, 2018 to October 20th, 2019, up until the date of a termination on January the 16th, 2023, the claimant was in disobedience of a directive to resume work immediately in the letter dated September 27, 2018, Exhibit C12. The parties, as noted earlier, did not tender any evidence of payment for the court to deduce if there was an outstanding payment or arrears of salary. Although the claimant resumed duty on the 21st of October 2019 and appeared before the committee on 8th November, the claimant is of the belief that she had resumed work, therefore entitled to pay. It is tried law that the person cannot benefit from his wrong. Equity will not allow a person to benefit from his wrong by using the law as an instrument of fraud, misdeed, or illegality. See Faka Yode versus Adeni, Enekwe versus International Merchant Bank of Nigeria, and Chieke versus Olusoga, citations all provided. These claims are baseless. Exhibit H and I feel accordingly. Cost and interest are the preserve of the court. The claimant has not shown to the satisfaction of this court how she arrived at 22% findings in this case and therefore fails. The case of the claimant fails and judgment is entered accordingly. I make no order as to cause. Signed, Honorable Justice Joyce A. Damachi. This is the judgment of the court.
As the court pleases.
As the court pleases, thank my lord for the judgment.
We appreciate my lord for the very insightful and well-considered judgment. We are very grateful, my lord.
Okay, thank you.